and we are discussing the effect of conversion in this class. So we already seen in the marriage what are the effects of conversion would be there, and what would be the effect of conversion in the divorce. Of course, we throw light on those points. Then we'll also see now the effect of conversion as far as the maintenance is concerned, how it can be made. Let me share my screen with the salutation, making it say good morning. I would like to say, yes, this good morning I would like to say, but I'm sure that you could see this good morning. Have a nice day with the flowers which I made it over there. Yes, everyone is joining one after another now. Yes, good morning to everybody and good morning to everyone. Yes, very welcome to the today class, and we will deal the effect later on if the time would be left over there. Then we'll go to the parentage. That is, who is the, what is the paternity and what is the maternity and how it will be there in the Muslim law. We will see it. So before that, I will also throw light on the effect of conversion in the marriage. We already studied, but I will throw light on it. Then effect of the conversion and the divorce is concerned. Then I will come to the effect of conversion for the maintenance. Because when you say the maintenance, naturally, a person who changes the religion at that instance automatically goes away. But where the Muslim man who changes the religion, then he cannot say that I changed the religion, I could not in a position to give. So what is in detail we will see when we go on the topic. So now time is 9:32. So one after another joining over there to the class. Yes, I saw the good morning. Yes. Yeah, there are the people over there. Okay, let me drag to this side so that it will be easy for the other people to see it. Yeah. Mm. Then now I will change the screen. I would like to show you the what would be the situations where the Supreme Court dealt it regarding the conversion is concerned. There, the Supreme Court made it very much clear to maintenance regarding the effect of conversion is concerned. Yes, I will make you. Yes, this is the Supreme Court. Is it? Let me ask you, what is that? Any questions? The building which I have shown over here is. I will drag it, then I'll ask it. Yeah, the people are there now. I could see on the screen. Could you see the screen, Kiran?
Yes, sir. I think it's Parliament,
Could
not
you see
Supreme
the
Court.
screen?
Yeah, yeah.
Kiran,
Hello?
Kiran.
Yes,
Okay,
sir.
speak.
I can see it. I think it's Parliament, not Supreme Court.
Could you see the screen, please?
Yeah, I can.
Either if you could not in a position to speak, you can chat also. I could hear you.
Yeah, yeah. I can see the screen, sir.
What is there on the screen?
I think it is either Supreme Court or Parliament. I think it's Supreme Court.
Yeah, yeah, thank you very much. It is the Supreme Court. See, if anybody has not seen it, please, I'm showing the. See, the Supreme Court has given a good decision, judgment. I don't know whether you know or not. You know what I say? Love jihad. Love jihad.
Yes, sir.
LOV. Yeah, what is love jihad?
It's a term quoted by BJP to win elections.
Time?
It is a Muslim man marrying a Hindu woman so that he can convert the religion, and it's a complicated term. Thing, sir.
Yes, yes. See, why I have given this, no? Do you know the case law which is there for love jihad?
I think it's one boy in Kerala. I think.
Yeah, that's very good. I appreciate your knowledge of how it. Yes, Kirina is very much like there is a case is Hidayah case. Now I will see. See why I am giving this case is it is a conversion. How it is having an impact, whether it is having impact or not, that we will like to see it. In certain places, it is a fundamental right. I repeat, it is a fundamental right to marry anyone, irrespective of the religion. But Special Marriage Act clearly gives no religion bond would be there. You can marry. Special Marriage Act is there, and with that we can marry anyone. Intercaste marriage are encouraged by the Supreme Court. So the purpose of showing this is I would like to share it now. Yes, let me close it. Then I will make it out. Yeah. So here, what they said in this case law, the Supreme Court, and before I could go, I want to see that what the Supreme Court says. Then I will come to the point. Right to convert is a part of fundamental right of choice. I repeat, right to convert is a part of fundamental right of choice. The Supreme Court made it very much clear. The observation are part of 61-page recent judgment published by the Supreme Court in the Hidayah, not Hidayah, Hadia case. Hidayah, no, Hadia, Hadiya, Hadia, not Hidayah. Hadia case. The Supreme Court on Monday held that a person's right to choose a religion and marry an intrinsic part of her meaningful existence. Neither the state nor patriarchal supremacy can interfere in her decision. So, the 61-page recent judgment published by the Supreme Court in the case of Hadia, where the 26 years old homeopathy student who converted to Islam and married a Muslim man. So now the question comes over there. Can we give such a choice to a woman or a man to marry anybody of choice? The answer, they say, yes, a man or a woman doesn't matter, and they can marry to whom they like it. So that was the decision which is given in the Hadia case, and Mrs. Hadia's marriage to Shafin Jahan and her husband Shafin Jahan, the High Court had called the marriage as a sham and referred to as a love jihad. It is, they said it's a love jihad and it's a sham, and it is only for the lust they are marrying over there, and it is that day the Supreme Court bench said, in short, allowed the Mrs. Hadia to rejoin the Jahan. Mr. Jahan, Chief Justice Mishra said detailed judgment would follow later in the case, which top judges termed as a unique judgment. So at the time, Chief Justice Mishra was there, and he has given the judgment regarding the Hadia case law from the Kerala is concerned. So a conversion is there. In conversion, nothing is going to be changed, but only the point is comes over there. And then suppose if they want to claim the inheritance or succession, that is the inheritance, that is same thing, adoption and maintenance are concerned. Yes, a little problem would arise over there, but section 125 is there, which doesn't care and whether he is a Muslim or a non-Muslim. So now we'll see some of the points in here. How a Muslim marries a woman. Suppose a Muslim male marries a woman who was a Hindu prior to marriage, but she convert to Islam and gets married. After some time, she renounces her Islam and convert to Christianity. See, earlier she was Hindu, then converted to Islam. Again, she renounces Islam and convert to Christianity. At that instance, can we say that marriage is dissolved? So this will not ipso facto means with the proof saying that dissolve the marriage because she has not re-embraced her former faith, that is the Hinduism. For instance, and if Hindu woman converted to Islam, married over there, later on she renounced Islam and convert to Hinduism, automatically the marriage will be dissolved. So I will make it clear in the case law here. Had she re-embraced Hinduism, it would have had the effect of immediate dissolution of marriage bond. So it is observed in the case law of Munwarul Islam versus Rishu Arora, where a Hindu wife converted to Islam at the time of marriage, on her reconversion back to her original faith, that is Hinduism, her marriage to dissolve. From where she came, again she goes back to the same place, then automatically the marriage will be dissolved. Uh, yeah, her case falls under the second proviso of, yeah, yes, reconversion to back to her original faith. If original faith would be there, and her marriage should have to dissolve. So her case falls under the second proviso of the section 4 of the Act, and pre-existing the Muslim personal law, and which the apostasy of the either party to the marriage ipso facto dissolves the marriage would apply. So now we'll see how the if a husband renounces Islam, suppose conversion is there, husband, the marriage stands automatically dissolved. Thus, if his wife remarries even before the expiry of iddat, she will not be guilty of bigamy. Yes, we discussed in the earlier class of 494. So when the husband himself is married, renounced Islam at the time, the wife need not to observe the iddat, and she will go for the another marriage. That another marriage is not said to be the bigamy. That we discussed in our earlier class also. As here I am again repeating it. So the first husband thereupon filed a complaint against the wife, her father, and her second husband, that under 494 of bigamy, it was held that no offense has been committed. At that instance, if the husband renounces from Islam, so it says that no offense was committed. That is the point over here. Okay, let me come back again to the. So the court remarked here in that case law, it is said, whatever the view be taken of the uncertain status of the parties during the period of iddat, and however illegal and void under the Mohammedan law of the second marriage of the woman during the period of iddat may be, there is no foundation of any charge under 494 of the IPC against her. Her second marriage is not a void by reason of its taking place during the life of her prior husband, but by reason of special doctrine to the Mohammedan law of iddat, which the Indian Penal Code has nothing to do with. So what I want to say over here is, if the husband renounces Islam, at that instance, then the wife can go for the second marriage without observing the iddah, and that is I want to impress upon you. So that was the thing which I want to make it out. And let me see, in the case of the divorce is concerned, suppose if a person wants to get the divorce, and how would be the idea behind it. So when the divorce comes, if a married woman, that is before the marriage she is a Hindu, then he converted into the Islam and married over there again from Islam, when she goes back to the Hindu religion again, then automatically marriage will be dissolved. And whether marriage would be dissolved over there, whether she is entitled to get the maintenance or not. So at the time, a divorced wife is there. When she changes her religion from there, at that instance, the doubt will come. But section 123 is there, which give the remedy to the her to get the maintenance from her former husband. So now you will see, suppose the husband himself is renounced the Islam and embraced the other religion. At that instance, can the divorced wife file a case against the husband? The answer is yes. Even though husband changes her religion from Islam to another religion, but it is not a bar. Still, a divorced wife can file a case against the husband under the CRPC 123, or under the dissolution. There is a marriage 1986 Act is there, which I discussed earlier under Section 3. That is the Muslim Women's Protection of Right on Divorce Act 1986. By that also, if the just and fair maintenance is given, at that instance, it is well and good. If just and fair maintenance is not given in the period of the iddat, at that instance, she can approach to the 125 section for the CRPC to get the maintenance. So now I will change the screen to see what is the other effect of the would be there in this case law. Yes, in this. So let I change the screen. Here it says conversion from Islam. I repeat, conversion from Islam affects a forfeiture of the pre-existing maintenance right. That is the law says. Conversion from Islam affects forfeiture of the pre-existing maintenance right. So now we will see how it is. When the husband renounces Islam, the marriage is at an end, and so maintenance can be claimed by the wife during the iddat period as per the Muslim law. But as per the CRPC provisions, can be obtained, claimed beyond the iddat period also for the judgment of Supreme Court in the Daniel Latif case law. Now we'll see the Shia law decides the quantum of maintenance by taking into consideration the requirement of the wife. So how much the quantum of maintenance would be there? So it will measured and the requirement of the life under the Shia law. And where the marriage is terminated by the death. Now we will see. Where the marriage is terminated by death of the husband. Suppose the husband is no more over there. Can a divorced wife having a right to claim from the legal heirs of the husband? It is a question. So when the marriage is terminated by the death of the husband and the husband is no more, both under the Hanafi law, that is enunciated by the Hidayah and Braille Digest and Shia law in the books of the Imamiya written, the widow has no right to maintenance. I repeat, when the marriage is terminated by the death of the husband, and both under the Hanafi law and Shia law, the widow has no right to maintenance. Next, even if pregnant at the time of the death of her husband, even though she is pregnant at the time of death of her husband, and at that instance also she has no right to maintenance. After the husband death, the widow is not entitled to maintenance even during her period of iddat also. Because once the death was over, then even she cannot claim for the maintenance in the during the iddat period also. Husband's liability to maintain his wife is his personal liability, which comes to an end upon his death. So what is it clearly says the liability of maintenance is a personal liability. So at that instance, the personal liability dies with the person. That is what we see in the maximum. That maximum is actio personalis maritam cum persona, and this we have read it in law of tort. I repeat, actio personalis maritam cum persona. That is a maxim. A personal action dies with the person. So here also claiming the maintenance from the husband, it is a personal liability of the husband. So when a husband dies over there, then automatically liability of the husband also dies with his death only. That's what I want to convey. So it is not obligated to maintain the father if he is able to earn in Shiala. Of course, the Shiala maintenance of the father is concerned. If not obligated to maintain the father, if he is able to earn in the Shiala, if father is having a good enough money, at that instance, maintenance father is not necessary under the Shiala. But in the Sunni law, it is obligatory to maintain even if he is able to earn himself. So Hanafi law, it makes clear that even the father is also a very earning member and he is having the money, but still in the Hanafi law, the son has to give the maintenance to the father. So that is about the conversion is how the conversion would be there and how it will be take effect and what is the impact of the conversion and if death is there and who will maintain it. So these are the differences between Shia law and Sunni law and we discussed over here in this up to now. Now this is a small topic, hence I cleared it in time. And then we will go to the next topic. Before I could go, I would like to ask the students if they have any doubt in this regard. So can I ask anyone, like I say, Madhu Mohan is there. Madhu Mohan, did you join from the 9:30 or you join in the middle?
Yes, sir.
Yes,
Hello.
I'm speaking to the Madhu Mohan. Madhu Mohan can speak. I'm hearing you.
చెప్పండి సార్.
Yes. Did you join from the beginning or you join in the middle?
బిగినింగ్ సార్ 9:32.
You joined. Okay. Can you tell me? Suppose the husband renounces or husband convert from Islam to other religion. At that time, can a wife can claim the maintenance from him?
సార్ మ్యూజిక్. హలో.
Yes, yes, I'm hearing you. Did you understand my question?
ఎస్
అదే
Suppose
ఇస్లాంలోకి వెళ్తే క్లైమ్ ఇవ్వచ్చా అన్నట్టుగా.
ఇస్లాం నుండి వేరే రిలీజన్ కి వెళ్ళిపోయింది అనుకుందాం హస్బెండ్.
రిలీజన్కి
అటంపుడు వైఫ్ కెన్ క్లెయిమ్ ద మెయింటెనెన్స్ ఫ్రమ్ ద హస్బెండ్.
నో ఛాన్స్.
Yes, anyone can help him.
ద లయబిలిటీ ఆల్సో డైస్ విత్ దట్ పర్సన్.
డెత్ అంటలేను నేను ఇక్కడ, రెనౌన్స్ అంటాను.
కన్వర్షన్ అయినా కూడా కన్వర్షన్ అయినా కూడా ఉంటుంది కదా సార్ మరి.
డెత్ అయితే షీ కెనాట్ క్లెయిమ్. కానీ కన్వర్షన్ అయింది అనుకోండి, షీ కెన్ క్లెయిమ్. కన్వర్షన్ అయినప్పుడు షీ కెన్ క్లెయిమ్ ఇట్. డెత్ అయినప్పుడు నో క్వశ్చన్ ఆఫ్,
నో క్లైమ్.
పర్సనల్ యాక్షన్ డైస్ విత్ ద పర్సన్. సో అది కాన్సెప్ట్. So that was the thing. So now I will check it whether I kept it the parentage or not. Then we'll see what is the parentage. I will close down this thing. Then yes,
The-
I will close down. Yes. Any question you want like to ask? Yes, please.
నో సార్.
Yeah, if you do you have any question, you can ask me.
నో సార్.
Okay. So now, see, this is a small one. Conversion to other religion. At the time, the maintenance is there or not. That's we discussed it over there. But one thing is very much clear. When the conversion of a husband to another religion, at that instance, even wife can file it, claim the maintenance. But if the husband is no more, at that instance, the wife cannot get any maintenance. That's I want to clear it. So now the next point is legitimacy and acknowledgement in Muslim, and maternity and paternity, how it is established. So that we will see, because we have some time. Then we will throw light on this. Then we will stop it. So now we will see how a legitimacy will be formed over there. So let us see parentage. So parentage means who is the father and who is the mother. That is called the parentage. Yes, close down your speakers. Mute it. I am hearing the sound. Mute it, then you can listen. Madhu Mohan, your speaker is on, so you mute it. Yeah, mute it. Thank you very much. Here, parentage in the sense, parentage is the relation of parents to their children. The parentage includes maternity and paternity. And I'm sure that you know what is maternity and paternity. Maternity means mothers. Paternity means father here. So maternity is the legal relationship between the mother and the child, and paternity is the legal relationship between the father and the child. So there is no doubt of the maternity and only doubt of paternity. I would like to ask any one of it so that at least I have an idea that whether you are following me or not. So now I will ask any one of the person who is here. Okay, it is changing over there. So better I will make it out. So this is the point. And triple V. Let me ask, because you put the microphone. You kept it the earphone. DU double V. Duvu. And Duvu, could you hear me? Yes, I am asking DU double V. Yes, your speaker is on now. I unmute it. Now you tell me, maternity is no doubt at all, and paternity is doubtful. Do you agree to this statement? I can hear you. You can speak. Is anybody in the class?
Why, sir? Why doubt?
Yes, please.
Why for paternity in doubt, sir?
Which one?
అగ్రి అవుతున్నాం సార్.
Sir?
Yes, speak.
పేరెంట్ ఎవరో చెప్పలేము సార్ ఖచ్చితంగా.
Sir, what is the doubt? Why
సార్
paternity? For what? For paternity,
Yes,
what is the doubt, sir?
paternity in the sense doubtful whether he is
No.
equal to the same father or not, but maternity is not doubtful.
అవును సార్.
Yeah, because but the child begotten by the mother definitely shows mother and he is a son and he is a mother. Regarding the begotten is concerned, it is not surety that what is the who is the father of it. So that the people say paternity is a doubtful, maternity is a obvious factor. It is not a doubtful. So doubtful in the sense, suppose if a woman is leading a what is a promiscuous life. Promiscuous life means having a BBC with the many other people. So at the instance when she conceived, whether she conceived with the husband or whether conceived with the other people, that is the doubtful they say. So that's why I put this proposition. Maternity is not a doubtful, but a paternity is a doubtful. So now for our understanding here, for our clarification, so parentage is generally used for a legal relationship with the child, with the parents, and these relationships are associated with the certain rights and duties, such right of inheritance and maintenance and guardianship. So why I am giving this point is, suppose if the parentage, the paternity is not proved over there, then son will not inherit the inheritance or maintenance and guardianship because he was begotten by the other man. So the biological father is different, the father which he is staying over there. So in that regard, the paternity is a very much important factor over here. So we will see when a person wants to get the maintenance and inheritance and other rights are concerned, then he should be born in the valid marriage. That is the point. He should be born in the
Yes.
valid marriage.
Valid
Then
marriage.
only he will be entitled for all the rights. Suppose if he is not born in the valid marriage, tie of the valid marriage, and such a person or such a son or a daughter, child is called illegitimate child. So only legitimate child to prove it, this parentage and maternity is proved over there. So how paternity is established in Muslim law? Of course, the modern science is clearly makes a DNA test is there where we can a conclusive prove that he is the father of the so and so person. So paternity of a child can only be established by marriage between his or her parents, and his the point here is between his or her parents in the sense a legal validity of the marriage should be there. That's my point. The marriage may be valid or be irregular, but does not become a void. Paternity is established in the husband of the mother of a child. So the paternity is established in the husband of the mother of a child. Even a mother of the child also shows the paternity of a child. So that is the point. Mother will say that yes, he is a father, and you are born to his this man. Of course, the way there is a valid marriage would be there, and that is enough. Or subsistence marriage is there automatically paternity will be established because in the school records also it is put it over there, and a ration card also the name is there. So it is deemed that the paternity is established over there. So there is no doubt at all, unless until somebody knocks the door that he is not the real son of so and so father. So paternity is established in a person said to be a father by proof or a legal presumption. But the two way, if the question comes by proof or legal presumptions that the child was begotten by him on a woman who was at the time of conception his lawful wife. So lawful wife and a valid one and child was begotten. So that is a proof that the child is a legitimate child and he is a parent of the child and was in good faith and reasonably believed by him to be a such or whose marriage being valid. So A marriage should be a valid marriage, then only the paternity would be there and there is a conclusive proof. So, an issue of wide marriage has neither paternity nor maternity under Shiala. So, wide marriages, there is no paternity and there is no maternity under the Shiala. But in Sunni law, even irregular marriages, there is a paternity will be there. Provided the irregularity will be removed, then becomes a valid marriage. When it becomes a valid marriage, automatically paternity will come to the proof of that boy or a child. So now, how maternity is established in Muslim law, and the establishment is there if he is begotten and given a birth to a boy or a girl, then automatically then she is the mother of that boy or a girl. So under Sunni law, the maternity of a child is established in the woman who gives birth to the child, irrespective of whether the birth was the result of a valid marriage or adultery. Here, adultery is said zina in Arabic terminology. Zina, zina, means illicit intercourse or illicit BBC with the other person. Even that child is born, but still maternity would be there under Hanafi law, and it is considered. So, zina is an Islamic law concerning the unlawful sexual relations between a male and a female who are not married to one another through a nikah. That is a tie of band of marriage. Nikah, Nikah. It includes extramarital sex and premarital sex. It also includes adultery, that is the consensual sexual relations outside the marriage. So here, in the maternity is concerned, yes, in the Sunni law and mostly the Hanafi law will regard it. Yes, he is. But whereas the paternity is concerned, no, the father can deny it. But under the Shia law, neither the mother can adopt the child nor the father can adopt the child or consider the child, not adopt the child, consider to be a child. That is the reason. That means if a person born, if a child is born, rather I can use that. Of course, person includes everybody, including a child and fetus. So if a child is born to a Shia law, not within the valid marriage, then the child belongs to none. That is the so that is called a wide marriage and has neither paternity, the child, nor maternity under Shia law. But in Sunni law, at least maternity would be there for the child, but no paternity under the Sunni law. So under Shia law, only birth is not sufficient. Only birth is not sufficient to establish the maternity. It has to be also proved that the birth was the result of a lawful marriage. A lawful marriage would be there to establish the paternity as well as the maternity is concerned. So now we can say under Sunni law, an illegitimate child has his maternity in the woman who gave birth, and the child is entitled to inherit from the mother alone. Even though the child is born illegitimate, our child is the product of zina or adulterous act, and if the child is born over there, and still he will be entitled from the mother side, inherit from the mother side under the Sunni law. But in Shia law, it is not in that way. If a illegitimate child, neither he belongs to the father nor he belongs to the mother. Means neither the wife, the mother can claim it, nor father can claim it. But under Shia law, an illegitimate child has neither the maternity in the woman who gave birth nor paternity in the father. So in Shia law, the illegitimate child can neither inherit neither from the father nor from the mother. In other words, illegitimate child could not inherit anything from mother or father. So that is which I would like to share in the paternity and maternity is concerned. So let me go through because still we have 10 minutes in our hand. So 5 minutes I will give for the participation. 5 minutes I will teach now. So legitimacy in Muslim law. How the legitimacy is there? A person born in a lawful marriage. See, point is lawful marriage means valid marriage. Is said to be the legitimate child of the spouse. So the main point in case of the legitimacy of a child is the marriage between his or her parents. Here, her parents means the child parents here. And his marriage means his marriage with the wife. So that is the which I want to make it clear between his or her parents. Uh, Means the marriage should be a valid marriage, a lawful marriage. At that instance, we can make the legitimacy in Muslim law. So special notes regarding the presumption of legitimacy. How do you make presumption of legitimacy? So here the points are given. Presumption of legitimacy under Muslim law is a child born within 6 months after the marriage. Yes, a child born within the 6 months after the marriage, that child is illegitimate unless the father acknowledges the child. So if a person born within the 6 months of marriage, the child is illegitimate unless the father acknowledges. He says, "Yes, he is my child." So now you understood what it means. Now the second point is says a child born after 6 months from the date of marriage is presumed to be legitimate. So after 6 months, if the child is born over there, he said it is presumed to be legitimate. That's the second point. The third point is a child born after the dissolution of marriage is illegitimate, provided the condition should be fulfilled. And the conditions are under Shia law, if born within 10 months, if the child is born within 10 months after the dissolution of marriage, okay, it is a very, okay, we can consider it. Under Hanafi law, if born within 2 years, of course, practically is impossible. After the dissolution of marriage, if the child is born within 2 years, and which is practically or sensibly impossible now under Hanafi law. And the C under Shafi and Maliki, if born within 4 years, it is also practically impossible. I don't know why this provision is put over there. That's why uh, the presumption of Indian Evidence Act will be taken into consideration, and this B point and C point is overlooked. Yeah, and C, A point can be considered if it is within 10 months is concerned. Now we will see how the Indian Evidence Act 112 says regarding the presumption is concerned. So legitimacy when conclusive presumption under the Indian Evidence Act 1872. If you see the section 112, there is 112 of the Indian Evidence Act. If a child is born during the marriage or within 280 days, 280 days, within 280 days after the dissolution of marriage, the child shall be presumed to be the legitimate child of the spouse. Yeah, 280 days period would be given over there, and that is a sensible. That's why the Indian Evidence Act overrides the personal law here. So Indian Evidence Act supersedes the rule of Muslim law. Supersedes means overrules. Climb over. Supersedes the rule of a Muslim law. The question arises whether the provision of the Indian Evidence Act supersedes the provision of the Muslim law. The opinions are divided. The balance of authority remains in favor of the Indian Evidence Act. Yes, Indian Evidence Act overrides the Muslim law. And the Muslim law statement provisions which are impossible for practical reasons are concerned, and their Indian Evidence Act coming to our rescue in such a situations. So now presumption, how could we take the child is a legitimate and we follow the 112, but not generally the other laws are concerned, where one says 10 months, another says 2 years, another says school says 4 years, and we will follow only 112 of the Indian Evidence Act regarding the presumption of a child who is a legitimate child. That we will see, and in the next class we will see, because still we have the 6 minutes in our hand. Then I will give the chance for the participation of the students in the class so that they can express their views or they can ask me the doubts if they do have it regarding what I covered just now. And we will see the what are the conditions for a valid acknowledgement of paternity under Muslim law. So what are the conditions should be there for the valid acknowledgement of paternity under Muslim law? We will see in the next class. And now the 10 is there. Now this is chance for the students to ask any questions. See, now they have joined. Vipula Kumar Danki joined just now. Danki, I don't know how that you got it now because the class, It starts exactly by 9:30. See, when the timetable is already given over there, and the timetable make it very much clear that our class will start by 9:30 and by 10:15 exactly, and with the 5 minutes giving the question hour, not question hour, question time. We can say question hour means it takes a long time. So now you may ask the doubt which you have till now, which I discussed. Please, you can share something to enlighten me, or I can share something to enlighten you. And this is the reciprocal process of learning. Yes, anybody? Uh, I could not see any raising the hand of anybody here. So uh, I will ask myself only. Navya, NR. Are you hearing me? And yes, I made unmute to you. Now you can speak. I could hear you. Navya, Navya, NR. Rather, I can say NR. That is that I could see here. If you speak, I could see on the screen your name. Pardon? Yes, speak, speak. See, when I speak, your my voice should be very much clear so that you could understand. When you speak, your voice should be very much clear so that I could understand. When I could understand, I can give the answer to your question. And if the difficulty comes over there, you can send me a chart so I can see the chart. Then I can give the reply to you. Yes, I could not hear anything from the Navia because she spoke, but I could not follow it. Yes, any person who would like to ask me, you can have the right to ask me. Still, we have in our hand some time with us. So meanwhile, I can complete your doubts. Yes, no doubts are there. So everything is very much clear. Say at least yes or no so that I could feel happy. I will
No
show
doubt,
you.
sir.
Yes. See, the point here is I will make a summarize you regarding the conversion is concerned. Suppose husband converted to other religion from the Islam. At that instance, wife can claim the maintenance. Now I will put the question in. If the husband dies, she cannot claim it because personal action dies with the person. That I made it clear. And regarding the maternity is concerned, yes, in the Sunni law, Hanafi law, yes, please ask me. Yes, if you have any doubt, you can ask me so that I could give the reply to you. Yes, speaking, DUWB. Yes, you can speak very clearly so that I could hear you. Yeah, because I saw here, expand the panel to show the video. Why is it so much? See that much big it is there. I in the video I made it only thank you. I think I could you could see me the thank you which I put it there on the screen, isn't it? Yeah, because Gujuru Naresh are very clear in class, sir. Okay, that is Amreshwar is made. Gujuru Naresh also said the same thing. Yeah, that is very nice. So before I could close my, because still 1 minute is left with us, and tomorrow class we will see what are the valid condition for the acknowledgement of paternity is concerned, and then we'll try to finish that chapter tomorrow if possible, and we'll meet you again tomorrow by 9:30. If you are present at the 9:30, then you need not to ask for the lobby, and if you come late and you are supposed to ask me, that is the thing which yeah, automatically in default it will be locked over there. Then you should be standing in the lobby, and until I admit you, and you will not listen my class. So with this, I would like to close my today's session. And thank you very much for patient listening and asking the doubts. If you have it, then I can share it. Then now I stop the sharing of my stop sharing. That I will go for the stop sharing. Yes. Then I will stop my yes end meeting. Bye
Thank you, sir.
and thank you and goodbye to everybody. Yes. Thank you very much.